We closed the last lecture with a look at the Chinese exclusion case. We're beginning now to look at the constitutional doctrines that underpin immigration law. The Chinese exclusion case is fundamental to that, and that's why I asked you to read it. There are a number of questions that we left with at the end of the last lecture, and they are the following. Understanding the plenary power doctrine. What is the source of the federal immigration power? Where is this power vested? And what is the role of judicial review? It may surprise many of us to learn that the constitutional doctrines that define immigration law today in the United States were formed during the era of the Chinese Exclusion Act. Congress in 2011 apologized for the Chinese Exclusion Act that was passed first in 1882. So what is the plenary power doctrine? This is a short overview of it. You'll find more information in the reading. The plenary power doctrine protects from judicial scrutiny the substantive decisions of Congress on immigration admissions criteria. This is one of the lessons you should have learned from your reading of the Chinese exclusion case. Another important tenet of the plenary power doctrine: courts lack power to review congressional exercise of its plenary power over immigration. So the first answer to what is the plenary power and what is the plenary power doctrine, it's a power of Congress. It's Congress's power over immigration. And the power is plenary in that it is not subject to ordinary constitutional limitations. Another doctrine that we'll discuss in this lecture and in the next lecture that again surprises many people who are unfamiliar with immigration law. What are some other components of the plenary power doctrine? I want to quote from a Supreme Court decision in the year 1977. The case is known as Fiallo versus Bell. Over no conceivable subject is the legislative power of Congress more complete than it is over the admission of aliens. So what does this mean in practice? Well, for example, the Supreme Court has upheld the exclusion and deportation of certain races and nationalities and non-citizens with particular political views. The judiciary does not review these substantive decisions of Congress. The plenary power doctrine is judicially created, and we see it in the Chinese exclusion case and some related cases from that era. It's a sweeping power that Congress has, and one question that arises is, where do we find this power in the United States Constitution? And the answer to that is not easy. Let's look at some of the provisions that underlie the immigration authority of Congress. Nowhere is it explicitly defined. The U.S. Constitution, of course, is a constitution of enumerated powers for the federal government. For Congress, what that means is that Congress does not have authority to legislate unless it is specifically given in the federal Constitution. The closest we come to finding a clause in the United States Constitution that's about immigration is the Naturalization Clause. The Naturalization Clause, Article 1, Section 8, essentially grants Congress the power, quote, to establish a uniform rule of naturalization. Congress exercised this power as early as 1790 to replace the various laws in states on admission of citizenship. Some states admitted foreigners as citizens as soon as they landed on their shores. Others imposed longer waiting periods or other requirements. In 1790, Congress passes the first Naturalization Act. From 1790 to 1952, Congress required that only white persons could naturalize, and the courts during this period had to define which persons qualified as, quote, white. But the Naturalization Clause is a little bit of an uneasy anchor for the immigration power of Congress, because it's simply about becoming a citizen, as we talked about in week 1, the naturalization process. There are some other constitutional provisions that have been pointed to as a possible basis for Congress's power. The most important of these is the Commerce Clause, or the Commerce Power. That also appears in Article 1, Section 8, and in Clause 3, Congress is given the power, quote, to regulate commerce with foreign nations and among the several states, and with the Indian tribes. Earlier in Supreme Court history, the court preferred to view the immigration power as linked to commerce with foreign nations, not limited to the goods that are traded, but also the people that come and go. And lastly, in terms of specific powers listed in the U.S. Constitution, is the war power. And this one may not be an obvious place to rest immigration power, but Congress has the power to, quote, declare war, and in another clause, it also has the duty to, quote, protect each state against invasion. Some states have sued the federal government in recent years under this clause. They seek to recoup money spent for undocumented aliens, whether it's emergency health care or public school access, and they seek to do so on the ground that this is an invasion of persons who are not admitted into the country. None of those suits have been successful, but it's worth mentioning here. So those are the constitutional provisions that are most closely linked to immigration. But there's also, as you know from the Chinese exclusion case, the concept of an implied power. An implied power, as the name suggests, is not written specifically in the U.S. Constitution, but rather is implied from the structure or the nature of sovereignty. The Chinese Exclusion Act has an extended discussion of this. Under this theory, articulated by the Supreme Court in the late 19th century, immigration power in the United States government is a function of its sovereignty and foreign affairs power. And so I'd like to quote from a portion of the Chinese exclusion case. The Supreme Court explained that, quote, the power of exclusion of foreigners is an incident of sovereignty belonging to the government of the United States as a part of those sovereign powers delegated by the Constitution. So in the Chinese exclusion case, we don't see a specific constitutional provision invoked. Rather, we see sovereignty, foreign affairs, and the nature of things in the Supreme Court's reasoning. I would like to acquaint you with one more case that is associated with the plenary power doctrine. It's a case called AQ versus United States. The year was 1891. And again, one feature of the plenary power doctrine is that it's formed in the late 19th century in the midst of blatantly discriminatory laws against the Chinese and other Asians. The court said this in 1891, "It is an accepted maxim of international law that every sovereign nation has the power, as inherent in sovereignty and essential to preservation, to forbid the entrance of foreigners within its dominions, or to admit them only in such cases and upon such conditions as it may see fit to prescribe. In the United States, this power is vested in the national government, to which the Constitution has committed the entire control of international relations in peace as well as in war." So these are the parameters of the plenary power. It's Congress's power. It limits judicial review. In our next lecture, we continue to look at the plenary power doctrine and some ways in which it is relevant today.
The preceding program is copyrighted by Emory University.